Now, in our last video, we discussed a system for keeping you up to date, informed, and frankly, one so that you won't lose your mind, a subsystem coping with stress during criminal prosecution. Next, we're going to be discussing legal defenses, and because legal defenses is so broad and so case specific, I can only go into generalities, and we're going to break it into two parts, pretrial and trial, because there are types of defenses that are appropriate before a trial, and there are types of defenses that are only appropriate during a trial. Let's go over that and start with pretrial issues. Now, one of the most important pretrial issues and why you should contact legal counsel immediately if there is an investigation or if you or someone you love is arrested is because there's going to be the issue of bond. Bond can be handled at two separate times. One is at first appearance, which is held normally 24 hours after someone is arrested. That is usually the best time to handle a bond issue. However, because it's a brand new case, the judge responding is a duty judge, the prosecutor responding is usually not the prosecutor on the case. You can't see them on the camera because all you see is the judge's face. You don't see that in the room with the judge, there's a whole bunch of other people. But for those reasons, sometimes you have to do a bond hearing. It may be about bond conditions, getting relief from having a scram alcohol monitor, for example, getting relief from a condition where you cannot have access to the internet in the modern world. That's pretty difficult. So what we often suggest is that the court order that access to the internet is allowed, but prohibited access is not allowed, and that the criminal defendant have installed what's known as a type of filtering software, such as NetNanny. So these are bond issues, and those are things that are held long before trial. These types of hearings may be short, they may be long, but either way, they're held pretty far in advance of trial. So that's an example of a defense issue, because if you're paying money for a monitor of some type, and there are many different types of monitors, and or testing of some kind, drug testing, alcohol testing, this can be expensive. And we're very mindful of that. We're not trying to, run your bill up. So that is an issue that would come under the category of bond and bond conditions. These things are handled before trial, in the pretrial phase of the case. Additionally, there's the issue of discovery. Now, in earlier videos, you've heard me refer to a Rule 3.220B, Notice of Discovery, what comes back, a state attorney checkoff list, copy of the charging document, offense reports, supplemental reports, intoxilizer reports in DUI cases, DNA reports perhaps in a murder, sexual battery, firearms testing in gun cases, blood spatter analysis in violent crime cases, on and on and on and on. These are all discovery issues. Here's a growing one that people don't think about, Facebook. Often we have to do electronic or digital discovery through what's known as a specific notice of discovery. And sometimes the state says, no, we're not required to produce that. And we respond, oh, yes, you are. And after having won a major sexual battery case that involved a false allegation between an employee and a business owner, basically she was looking for money, we found that she was looking for money in her Facebook private messages. And here's something you need to really think about. I know a lot of people who won't give their phone number out to somebody that they've just met, and they'll go, no, I don't want to give you my phone number because, and they're concerned about privacy. This same person, and it might be you, will sit there and have Facebook as the application installed on their phone, and they will have Messenger installed on their phone. And then when digital discovery occurs, and this happened just yesterday, I have a case where there are over 470 separate files. And the first one is Facebook records. Every like, every private message, every comment, every group joined, a list of every friend, everything. Facebook keeps all of that information. It was over 1,000 pages of data from Facebook. So if your case involves electronic discovery, That is part of the pretrial phase, and that can be quite intense, involving a lot of hearings and a lot of effort, because let me tell you, when you've got one file out of 470 that has over 1,000 pages, that's a lot of reading. So sometimes people say, well, what are you doing on my case? And the answer is, I'm reading a whole lot of information, because if you've got one that's over 1,000 pages, 2 full reams of copy paper, you can imagine that the other 469, they may be shorter, but that's a lot of information that has to not just be read, but we have to go through all of that very, very carefully, looking for evidence that's admissible and looking for evidence that's inadmissible. Something to keep in mind when it comes to evidence, because a lot of the battle in the pretrial phase is what evidence is admissible. Just because there is evidence against you or someone you love, that does not mean it is necessarily admissible evidence that can be placed before a jury at a trial. This is what a lot of the pretrial battle is over, evidence. So we've covered bond issues, we've covered discovery, including electronic discovery. There's also what are known as motions to continue, because quite often discovery isn't finished by the time court is scheduled. We'll keep you informed on that. And we might need to use a motion to continue. This is why we often ask clients to sign a waiver of speedy trial. Now, no one in the modern era wins a speedy trial violation. I haven't seen one. I mean, just to be blunt about it. Back in the day, unethical prosecutors would literally keep people in jail longer than the maximum sentence for the crime simply by not bringing the case to trial. Well, this is how the speedy trial rule was created, but in the modern era, we just don't have people languishing in jail longer than the sentence they would serve. It just doesn't happen. It could happen, it probably will happen, but I haven't seen it. So that speaks volumes, considering I've been practicing for a very long period of time. So we ask most of our clients to sign a waiver of speedy trial because we don't want a speedy conviction. A speedy trial without all of the evidence being discovered and finding out all of the strengths and weaknesses is a recipe for a disaster. Well, it's also a recipe for a disaster in your personal life if every time you turn around, you're having to run down to the courthouse, explain to your boss or your employees, if you're a business owner, why you have to take the day off for what is essentially a pointless court proceeding where you have an agreed upon continuance that could be obtained by written pleadings and an order to the judge. I mean, I can't tell you how many times I've seen somebody go to the courthouse, sit around for hours, get called down to the defendant's podium. And this happened recently in Santa Rosa County in the Milton courthouse. The judge said, Mr. So-and-so, this case has been continued 8 times. Why are you asking for a 9th continuance? And the client was standing at the defendant's podium. And the attorney said, well, Your Honor, you continued this last time because we needed to depose a witness who had disappeared and resurfaced. We deposed that witness. They gave us the names of 3 more people that we need to take their sworn statements before court, depositions. The judge said, oh, okay, no problem. State, and looked over to state with a question mark in the voice because the state was nodding the entire time. That's why the judge telegraphed how the judge was going to rule. And the state said, that's correct, Your Honor, no objection. And sure enough, the judge granted that particular motion to continue. What struck me was this poor person is standing at the podium, and I know that their lawyer drugged them to court, having to take a day off 8 times previously, and this was the 9th time. If you're out of state, oh my gosh, is that expensive and a disaster. So anytime we can do something with written pleadings instead of an actual court appearance, that's more time effective, more cost effective, and less stressful for you and your loved ones. So we do that. Now, in addition, when it comes to legal defense, there are many different types of motions that lawyers can file. The 2 most important, in my opinion, that can absolutely put a stake through the heart of the prosecution's case are the motion to dismiss and the motion to suppress evidence for being unlawfully obtained. In order to determine whether or not you have a motion to dismiss, a lot of discovery has to be done because, frankly, there are only 4 basic grounds for a motion to dismiss, and 3 of them are in the "that will never happen" category. Things like the state has violated an immunity agreement. Never see it. The governor has pardoned you, yet the state is trying you. Never seen it. Another one would be double jeopardy. Well, I've actually seen that a couple of times, but we're talking like 1991. Haven't seen it since. Basically, when you have a motion to dismiss, what you're saying is that the undisputed facts do not give rise to a prima facie case, and therefore the case should be dismissed as a matter of law because there are no additional facts. Now, if the state disagrees, they can file something known as a traverse. So as a result, a motion to dismiss is very rare when compared to a negotiated dismissal, which is in the category of plea bargaining. Far more common for what's known as a dispositive motion, meaning it disposes of the case, is a motion to suppress. Now, an important caveat. Sometimes a motion to suppress will not drive a stake through the heart of the vampire, okay? It'll wound it. And that wounding may result in a more favorable plea bargain because a particular piece of evidence is ruled inadmissible and the state is sitting there going, well, we can go forward, we can take this case to trial, but without this, it might be a problem. Perhaps a substitution of charge would be a better course of action to settle this case, perhaps a reduction in charge. The two are separate. So these things affect plea bargaining, both these types of motions, as do discovery motions generally. And then we also have the issue of pretrial depositions. You have to pay for a court reporter to be there, usually $125 to $150 for the first hour, around $95 for the second hour. And what the court reporter does is they sit there and have this funny looking little keyboard where they're typing in code that they have to go to school and learn literally everything everybody says, word for word, verbatim. They also record it. Well, if you want a copy of the written transcript, that's going to have a per page cost. So depositions should only be undertaken in cases where it's necessary. Now, I get that some of my colleagues feel the necessity to practice defensive law or to put on a dog and pony show. Oh, we got to take depositions, and what they're really doing is showing you how hard they're working. I take a different view. Depositions are expensive. I've seen cases where the defense lawyer walks out of the deposition room while I'm waiting to go in, and sure enough, the defense lawyer coming out, they're looking like this, and the prosecutor's skipping and dancing, writing on their file, adding new charges. That's a disaster. So depositions should be targeted, and your legal team will have internal discussions on this. We'll do staffings on it to decide whether or not we recommend depositions. So if depositions are recommended, we're going to have to serve a subpoena in many cases to compel attendance, and there are different rules for lay witnesses and different rules for police officers, and sometimes witnesses will show up without being served a subpoena, and that's a cost savings right there. But there's also a fee attached for each subpoena to be served. So these are important considerations. And then finally, there is medical discovery. Now, what is medical discovery? When we think of medical discovery, we think of civil cases, personal injury cases, medical malpractice, things of that nature. Medical discovery is often things like mental health records. Medical discovery can be medication records. Medical discovery can be brain imaging, particularly if we're doing mental health mitigation, which is something that I've really focused on since 2005. It doesn't mean we ignore the defense of the case, but quite frankly, sometimes medical discovery does cross over from mitigation into the pretrial phase. And even if we're going to ultimately use medical discovery for sentencing and mitigation of sentence, it still is done during the pretrial phase of the case rather than the trial of the case. And that brings us to our next segment where we're going to be discussing trial.